Bad faith in legal contexts can have serious consequences for individuals and businesses alike. When someone acts dishonestly or deceptively in a legal or contractual obligation, it can lead to lawsuits, financial damages, and broken agreements. Understanding what constitutes bad faith is essential for protecting your rights in various situations. At its core, bad faith refers to dishonest or deceptive behavior in legal and contractual obligations. It occurs when a person or entity acts untrustworthy in a legal matter, such as not following through with obligations, misrepresenting facts, entering agreements they never intend to honor, or acting dishonestly in legal situations. This concept applies across multiple areas of law. In insurance claims, bad faith might involve an insurer unreasonably denying claims, delaying payments, or failing to properly investigate. In business contracts, it could mean entering agreements with no intention of fulfilling them, or misrepresenting products or services being sold. Most states recognize an implied covenant of good faith and fair dealing in contracts. This means parties are expected to deal honestly and fairly with each other. When this covenant is violated, the injured party has grounds for legal action. Insurance companies are particularly scrutinized for bad faith practices because they hold more power than individual policyholders. They have greater financial resources, negotiating leverage, and industry expertise. Courts generally expect insurers to act with fairness and good faith toward their clients. Signs of insurance bad faith include failing to investigate claims properly, delaying payments for extended periods, denying benefits unreasonably, misinterpreting policy language, or refusing to settle cases fairly. Some policies specify timeframes for settling claims, while others rely on what courts consider a reasonable time based on the circumstances. Bad faith extends beyond insurance into employment relationships. For example, a manager who promises promotions or benefits to an employee without any intention of delivering is acting in bad faith. Similarly, an attorney who argues a legal position they know to be false is engaging in bad faith practices. To prove bad faith in legal proceedings, several elements must typically be established. First, a contractual or legal duty must exist between the parties. Second, one party must have failed to uphold their obligations in an unfair or deceptive manner. Third, there must be evidence of intentional misconduct or reckless disregard for fairness. Finally, harm must have resulted from the bad faith conduct. Courts may apply objective standards based on industry norms or subjective standards focusing on the intent behind actions. The specific legal standards vary by jurisdiction, making professional legal advice important when dealing with potential bad faith situations. Common examples of bad faith in business and contracts include failing to disclose important information, unjustified contract terminations, deliberate misinterpretation of contract terms, offering unreasonably low settlement amounts in insurance claims, and refusing to negotiate honestly. To protect yourself from bad faith dealings, take preventative measures such as carefully reading contracts, maintaining detailed records of all agreements and communications, getting important promises in writing, and consulting with an attorney when you suspect bad faith practices. Understanding the concept of bad faith helps individuals and businesses recognize when their rights are being violated and take appropriate action. Whether in insurance claims, business contracts, employment relationships, or real estate transactions, awareness of bad faith practices is an essential tool for protecting your legal and financial interests.